Oh, it didn't load? Okay. I guess we're gonna try this again. Here we go. All right, sorry about that. Apparently even more technical difficulties. Let us go ahead and, yeah, okay. Hi, I'm Brian, organizer with the American Union, and welcome to night 21 of our 24 nights of live streams, breaking down all 101 policy in the Trump-Biden peace plan, the set of legislative demands for the American Union in 2024. Tonight we're going to get into Title V and start looking at some new language tonight. But first, we always start these sessions off with the preamble to the Constitution, and so you're invited to join me in reciting it. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. You know, this is the purpose of the American Union, is to steer our country back, steer us back towards that mission, that vision, that goal that the framers laid out for us in the Constitution. Those are our 5 duties. And so tonight we're going to get into the 5th one, securing the blessings of liberty to ourselves and our posterity. And we'll spend 3 nights talking about how the Trump-Biden peace plan does that. Just as a brief recap, again, the American Union is a union of swing voters. And swing voters are the ones who have the most power. We looked at the polls last night and how the razor-thin margins in 7 key swing states that are going to decide the Oval Office. And there's numerous Senate races that are also exceedingly close. And House races as well. It's a small percentage of voters who control the balance of power in Washington. And by coming together with one set of demands across all 470 federal races, we can change the way that government works, not by trying to seize power for ourselves, but to use power to persuade Congress that it is in their best interest to serve the people. As I wrote my novel, Looking Backward from the Tricentennial, that lays out this paradigm as told from the year 2076. In the beginning has a quote from Martin Luther King, and where he says, "Our nettlesome task is to discover how to organize our strength into compelling power so that the government cannot elude our demands. We must develop from strength a situation in which the government finds it wise and prudent to collaborate with us." This is why it is wise and prudent for incumbents to collaborate with us, because by doing so, a union of swing voters can let them keep their jobs. If they refuse, we can kick them out of power, we can kick them out of office. But by drafting our own legislation, clean legislation outside the swamp of Washington, we can create our own metric for judging them by, not by party affiliation, but whether or not they are serving the people, by getting us back to these five duties. So, all right, let me go ahead and pull up the legislative package. Trump-Biden peace plan, of course, is named for our 45th and 46th presidents of the United States, 2 men whose cooperation could shepherd this through Congress before the election. And all right, here we go. So Title V, secure the blessings of liberty to ourselves and our posterity. And you can find a link to this document in the description below. Everything in the table of contents is hyperlinked. So we're going to start off with the findings and purpose. The Congress finds the following. 1. Americans have a constitutional duty to secure the blessings of liberty to ourselves and our posterity. The ability to vote is the most basic constitutive act of citizenship by which people can secure the blessings of liberty. 2. The United States is the only Western democracy that permanently that permits permanently excluding individuals with felony convictions from voting. Disenfranchising citizens who have been convicted of a criminal offense serves no compelling state interest and hinders rehabilitation and reintegration into society. Article 1, Section 4 of the Constitution of the United States grants Congress ultimate supervisory authority over federal election, an authority which has repeatedly been upheld by the Supreme Court of the United States. The 13th, 14th, 15th, 19th, 24th, and 26th Amendments to the Constitution empower Congress to enact measures to protect voting participation in federal elections. 4. Basic constitutional principles of fairness and equal protection require an equal opportunity for all citizens of the United States to vote in federal elections. The purpose of this subtitle is to secure the blessings of liberty for ourselves and our posterity by including all citizens of the United States under the umbrella of civic responsibility. Yes, that is the purpose. So let's talk for a minute about where this idea came from that incarcerated people shouldn't be able to participate in democracy. According to an April 2019 Newsweek article, there are at least 16 democratic countries that allow felons to vote while they are in prison. These include such radical countries as Canada, as well as Croatia, the Czech Republic, Denmark, Finland, Ireland, Latvia, Lithuania, Macedonia, Serbia, Slovenia, Spain, South Africa, Sweden, Switzerland, and Ukraine. And it's important to recognize that this isn't universal across the United States. There's actually 2 states, Maine and Vermont, that still allow incarcerated people to vote. There's only 4 democracies, and the United States is one of them, that restrict voting rights after a person's period of incarceration has ended. So again, the vast majority of countries, once you've served your sentence, once your period of incarceration is over, then welcome back. We don't tack on, most countries don't tack on additional punishments after the sentence is complete. We are an outlier. And there's evidence that this is that there's some racial bias in the way that this law is applied. There's been a number of stories in recent years about formerly incarcerated Americans being charged with new felonies for attempting to vote. In Texas, there was a woman named Crystal Mason. She served 3 years for tax fraud, and a year after her release, she cast a provisional ballot in November of 2016. Although she hadn't been told she couldn't vote, she was arrested and sentenced to 5 more years in prison. After appealing the decision for 6 years, it finally got overturned back in May. In Tennessee, a couple of years ago, there's a woman named Pamela Moses, who's a Black Lives Matter activist. And she was sentenced to more than 6 years in prison after being convicted of illegally registering to vote because she'd used paperwork from her probation officer that said she was eligible. And despite the fact the mistake was on his part, they found her guilty. She's quoted in the Guardian newspaper saying, quote, "It's a scare tactic what they did to me. It's like, if she went to jail for that, we don't need to do that. We don't need to follow her because we're going to be in jail for 6 years too." I would say it sends a confusing message to people who want to vote. Why should people be worried that they're going to be prosecuted for trying to do their civic duty, trying to be part of the political electoral process? Her conviction eventually got overturned, and rather than give her another trial, they just dropped the charges. So these are 2 black women who were both sentenced to more than 6 years, or more than 5 years for trying to vote, for registering to vote, and for casting a provisional ballot. Now, when it comes to actual voter fraud, a couple of years ago there was a guy named Donald Kirk-Hartle, who was charged with voter fraud after forging his dead wife's signature to vote with her ballot, he got sentenced to a year of probation. Edward Snodgrass in Ohio, he forged his dead father's signature on an absentee ballot and was charged with illegal voting. As part of the plea agreement, he got 3 days in jail. These were both white Republicans, and who very much, in fact, did vote illegally and very knowingly if you're forging someone else's signature. And they got very light sentences. And I'm not necessarily arguing for harsh sentences here. What I'm saying is, illegal voting should be against the law, but the idea that some citizens shouldn't be eligible to vote, we should abolish that idea. In the 18th century, it was property owning white men who had the franchise, who were able to vote. And then in the 19th century, then we allowed black men to vote too. And then in the 20th century, we allowed women to vote too. But we've still got millions and millions of formerly incarcerated people who are disenfranchised, who are unable to vote. And so it's the 21st century now. It's time to update that and have real universal suffrage, like so many other industrialized modern nations do around the globe. Couple other, another reason for this is one of the rallying cries for the American Revolution was no taxation without representation. And yet, when someone has been a formerly incarcerated person, may not be able to vote, but still have to pay taxes, may not be able to have any representation in the way that their tax dollars are being spent. So there are lots of good principled reasons why this provision, and as you probably can guess, the roots of this provision are rooted in the second of Dr. King's triple evils, racism, in which after the Civil War, Southern states rounded up black men and convicted them of crimes in order to disenfranchise them, in order to deny them the ability to vote. And so let's move on from that and with universal suffrage. So let me pull back up the legislative package and we'll look at sections 502 and 503 that explain exactly how we can do that. All right, section 502 is the definitions. These are pretty standard stuff. Election, to clarify everything that an election covers: general, special, primary, runoff election, convention, caucuses, primary election. All of these things are covered. And these are for federal office: the office of president, vice president, senator, representative, or delegate or resident commissioner to, in the cases of like District Columbia and stuff, to the Congress of the United States. So those are the federal offices. All right, and 503, all adult citizens eligible to vote. Any citizen of the United States being 18 years of age shall be eligible to vote in any election for federal office. So we've defined our terms. B, notification requirements. So anyone who's been convicted of a criminal offense under the law that previously been told that they could not vote shall be notified that they are now eligible to vote in elections for federal office. And then C is restrictions on federal prison funds. This comes from HR 1, the We the People Act, big omnibus voting rights legislation that the House passed last session. So this would withhold federal prison funds unless they had a program in place to notify incarcerated people that they were eligible to vote, and also make available any materials necessary. Those sections, the notification and the funding things, I should say the whole thing, this whole section 503 goes into effect January 1, 2026. So wouldn't affect this election, the next election. Wouldn't affect this election, but the next election. And then after 10 years, those last two are repealed. All right. Section 504, clarification of the Real ID Act. I'll just look at the text real quick and then we'll talk about it. For the purposes of boarding a federally regulated commercial aircraft, credential requirements of the Real ID Act shall only apply to persons required by federal law to show identification as a condition for boarding a federally regulated commercial aircraft. Yeah. So the Real ID Act was passed back in 2005, and the way it became law is there was this must-pass piece of legislation, the Emergency Supplemental Appropriations Act for Defense, the Global War on Terror, and Tsunami Relief 2005. Lots of impressive sounding stuff in there. And so the House and Senate passed different versions of this bill. It went to a committee conference, and then the House tucked the Real ID Act into this. And so, as we've talked about, the way that Congress can pass the Trump-Biden peace plan is by taking the text of a committee of conference bill and replacing it with this text, because it goes back to each chamber for an up or a down vote. And that's exactly what happened with this tsunami relief bill in 2005. It went back to the House and Senate for an up or down vote. Senators objected and said, "Oh, we don't think this should be, this national ID card system, this shouldn't be in here." And then they voted for it anyway, 100 to 1. And so the main threat of the Real ID Act is, it's very roundabout, but it says that non-Real ID cards, your driver's license, won't be accepted for identification purposes when boarding a commercial aircraft. Now, this was passed in 2005. It was supposed to go into effect in 3 years. It was supposed to go into effect in 2008. But then states pushed back, so they moved it to 2009, and then 2011, and then 2014, and then 2015, and then 2018, and then 2020, and then 2021, and then 2023, and now 2025. So for nearly 2 decades, they've been telling people Real ID is coming, trying to make people afraid that they will lose their freedom to travel unless they comply. And so Section 504 clarifies very simply that unless Congress has specifically passed a law requiring people to show ID, then it can't be done by rule. Once again, Congress is supposed to be setting policy. Congress is the policy setting branch. And if they want to make this a policy, they certainly have the ability to do so. But by trying to weasel this in sort of a backdoor way, that's not appropriate. So Section 504 would clarify the Real ID Act, protect the liberty to travel. All right, now move into Subtitle A, Stabilizing Government Systems. Let me go ahead and read the findings in Subtitle A. Congress finds the following. 1. Shutting down the government when a budget has not been passed is a uniquely American dysfunction that serves no rational purpose. 2. According to the Congressional Budget Office, the economic costs of the 5-week shutdown in December 2018 and January 2019 irrevocably lowered our GDP by $3 billion. 3. Similarly, no other country requires a legislative act to raise a debt ceiling in order to pay for the spending that the legislature has already authorized. 4. The ability to massively disrupt the United States economically creates perverse incentives for political actors and distracts Congress from Congress's primary responsibility of setting policy for the nation. The purpose of this subtitle is to change the default settings for basic governmental functions so they remain stable instead of continually requiring corrective action to avoid economic crises. Yeah, so the first of these is abolishing the debt ceiling. Now, the debt ceiling, again, well, all right, so the debt ceiling, this is the amount of money that the United States can borrow, and then Congress, it's a hard and fast number, and then it's got to be updated. Now, why do we do this? Well, this is something the United States made up back during World War I, because before that, Congress used to author, the Civil War and things like that. Congress would authorize the selling of $400 million worth of bonds. They would set very specific caps, say this is how many bonds we're going to sell. And then during World War I, they wanted to give some of that authority to the Treasury, and so let the Treasury sell bonds as needed. And so Congress set a cap. So this is how much debt you can run up. Now, since that time, in the last 100 years, we've increased that cap about 80 times. And this is not something other civilized countries do. To the best of my knowledge, Denmark is the only one to have a debt ceiling, and it's not a serious cap, it's just a theoretical one. In 2022, it was more than 6 times the amount of actual debt. So that would be like Congress agreeing to set the debt ceiling to $200 trillion. There would still technically be a cap, but it wouldn't be influence day-to-day operations, or it wouldn't influence things on a regular basis. You wouldn't have to increase it 80 times in 100 years. And so you might reasonably ask the question, well, why not just raise the debt ceiling to $200 billion or $200 trillion? Then we don't have to worry about it. Because it makes more sense to recognize the absurdity of the debt ceiling and just abolish it. And there's 2 reasons for that. One, the United States can't, to default on our debt would be incredibly stupid. But there are occasionally people who are willing to threaten to do something incredibly stupid in order to, get political attention, get political points, and try and use that leverage of knocking everything down, blowing everything up in order to advance their legislative priorities. So basically to hold the system hostage. And that is not a functional relationship for Congress, right? Congress is dysfunctional in a lot of ways, but giving people the power to hold everyone else hostage and the entire nation hostage is dysfunctional. So that's one reason, is to make government run smoother. But the other reason is because Treasury dollar bills. We talked about this a few days ago. Treasury dollar bills, sovereign money issued by the Treasury, interest-free, will replace the bank money that's currently circulating in the economy. And so it's going to make it unnecessary for us to borrow trillions and trillions of dollars, because we'll be switching from the borrowing money at interest and paying interest on it in perpetuity, $1 trillion last year, or to interest-free money. And so the debt will be paid off over a period of years. Treasury dollar bills will gradually make it unnecessary to borrow any more money. And so Section 512 takes these dramatic showdowns off the table and abolishes the debt ceiling. Let's go ahead and take a quick look at the legislative language. All right. Abolishing. So basically, it's technical and conforming amendments. Repealing this one section. 3101. Honestly, I don't remember exactly what that section is. Let's this is the public debt limit that we would be repealing. Yeah, so we're just going to repeal this one. Notice how here it says in the existing text may not be over $14 trillion outstanding at one time. The last deal over the debt ceiling that was worked out, specifically, it just says, come on, it specifically says that Congress is allowed to spend as much money as they want up until a date certain, and that date certain is coming up January 1, 2025. So the Treasury will not be able to borrow any more money come January 1, 2025, because we will have exceeded the debt ceiling. The debt ceiling wasn't lifted, it was just suspended. Now, ask yourself, is this like a rational way to manage government finances? Of course it's not. And we're setting up a crisis for less than 2 months from now. Right as Congress is changing, the president maybe is changing, we're setting up a crisis. And so let's just fix it. Let's just abolish the debt ceiling and move on. All right, and so then there's a couple technical and conforming amendments. And so where there's references, and so it's just reference, total public debt reference. And so, yeah, so just clarifying a few references as we go along, and then some savings provisions, and this would be effective on passage. All right, moving on to section 513, stabilizing Social Security. All right, Social Security. As you probably know, Social Security was passed back in 1935, and the idea is that it is an insurance program. You pay in, and when you reach the age of retirement, then you can collect. If you don't reach the age of retirement, then you don't get anything. It is an insurance policy. And so you collect this money in your retirement. And so that is supposed to sort of balance it out. We talked about funding mechanisms, the purpose of taxes. And so the tax is supposed to fund the money that's paid out. Well, in 10 years, we're supposed to run a deficit. And so what does that mean? Does that mean that seniors are not going to get the money that many of them are counting on? It's possible. So let's not do that. Instead, let's fix Social Security, strengthen it, and the way that we can strengthen it is by raising the cap on where people stop paying into it. So right now, there's a cap, and for 2024, that cap is $168,600 a year. If you make exactly that much, then you pay into Social Security. It's 6.25% on the employer and employee, and you pay in up to that amount. If you make $200,000, you stop paying in $31,400 earlier. You stop paying at that $168,000. You don't pay in it anymore, even though you're earning more. If you make $200 million, you still stop paying at $168,800. And so this cap, which is indexed to inflation, so it does go up a few percent each year. But this cap, as wealth inequality has become more exacerbated over the decades, it has created issues where a smaller percentage of the total income earned in the United States is going to fund the Social Security Trust Fund. So some people have proposed just abolishing the cap. Everyone just pays the same no matter what. Instead, as a starting point, as a middle ground, where section 513 would make it 25 times whatever the UBI amount is. So UBI is $16,800, a year to start for your American Union job. And so this would make the cap 25 times that. We talked about popularity polling support a few times, and this idea of protecting Social Security by raising payroll taxes on high income earners garners 66% support. So 2/3 of Americans support this provision. Yeah, all right. Well, we'll pull up the language real quick and we'll take a quick look. Nothing too interesting here. So the amount, the cap is 60. We're crossing out the 60,600 and saying that it's the basic wage. It is the product of the basic wage as calculated in that section we looked at the other day, and 25. So 25 times that. And that's it. And will go into effect January 1, 2025. Section 514 is restoring Chevron deference. And you can see here, we're just adding one new sentence to the existing law. If a statute that an agency administers is silent or ambiguous as to the proper construction, reviewing court shall defer to the agency's reasonable and permissible interpretation, regardless of the significance of the action or possible future agency action. So, all right, let's talk about Chevron deference. So this is a new issue. This is one that was added in July because this was the result of a Supreme Court decision. This was not something that this was settled. So for 40 years, back under the Reagan administration, the Supreme Court issued a decision in a case involving Chevron. And what that said, their decision, the Supreme Court said, all right, this is how according to the Constitution, this is how things should work. That if the law Congress wrote was vague or ambiguous, then, and the agency that enforced it did it in a way that was permissible and reasonable, then courts should defer to the agency's expertise. And, I say expertise is important here, right? Why would Congress write a law that's vague? Because they can recognize they don't have the specific expertise to fill in all the details. You've seen a number of times in the Trump-Biden peace plan where it said so-and-so and so has authority to issue regulations, right? People with the most expertise should be the ones setting the policy for the most part, right? And so Congress has done that. And some groups have pushed back and says, no, we want Congress to be more precise. We want Congress to set policy exactly. And since you've heard me say many, many times it's Congress's job to set policy, well, what's wrong with that? And there is nothing inherently wrong with that as a matter of principle. But as a practical matter, the people on Capitol Hill who have the expertise about these laws aren't lawmakers, they're lobbyists. And so if you require everything to be super detailed and spell out all the nuances of everything, lobbyists are going to be the one who write those policies for the benefits of their clients, not for the benefit of the American people. Whereas an administration, an agency has the ability to represent the American people in writing policy. They're being paid by the people of the United States in order to write good policy, as opposed to being paid by entrenched interests and then creating an incentive to guide policy in a way that benefits them. That's how it works. Again, having served in the legislature, I couldn't tell you how many times that lobbyists would come in like, all right, this is the language that we want, and I the Commerce Committee covered banking and insurance regulations. The lobbyists would come in, and many times we would just rubber stamp it. Oh, is this what so-and-so wanted? Okay, yeah, that's fine. Yeah, so Chevron, so restoring this is not doing anything new and radical. It is simply restoring what has been settled law for 4 decades. This language, I should say, comes from H.R. 1507, the Stop Corporate Capture Act, Representative Jay Paul from Washington. And she introduced this back in March before the Supreme Court decision. After the Supreme Court decision, Nancy Warren got headlines saying she was going to introduce something in the Senate, but I looked and I can't see that she has actually done so. So that's where this language came from. Okay, let's move on to section 515. This is another Supreme Court decision that was issued July 1st, and it was over an agency rule over debit card fees. Now, this rule about debit card fees was made in 2011 and has been settled for 13 years. But a company, Corner Post, they opened up a few years ago and said, you know what, we don't like this rule that you made back in 2011. We want to sue over it. Well, Congress has anticipated this sort of things, and they have set in statute a statute of limitations. They say, if you're going to bring a civil action over a rule or something like that, you have 6 years. 6 years to do it. And clearly, this was already settled. But the Supreme Court said, well, when Congress says you have 6 years to do it, that means from the first time that you've been impacted by it. And so if your company wasn't formed, whenever your company was formed and first impacted by it, then you have 6 years from that. It took a very tortured reading of the language of the statute to get to that decision. But that was the Supreme Court decision, and has happened many times in the past, clarifying the law, as again, there are at least 4 of the 101 policies are clarifying Supreme Court decisions. I know there's at least 2 in the prison reform language, and the 2 right here on these bump stocks. Anyway, so what's the problem with saying, well, you should be able to sue anytime? Well, besides the fact that Congress already set a policy of 6 years, it creates other technical problems, right? Because then nothing is settled. You can, just like that, in 5 minutes, you can create a new corporate entity who can then go out and say, oh, now I'm being harmed by this old provision. And the statute of limitations that Congress enacted becomes meaningless. This is one of the ways that, again, because Congress is failing to act, that the judiciary and the executive branches are sort of picking up some of the slack. Another reason, is that when a law is fresh and it's written, you have expertise. The people who wrote the rule have the expertise, and they're there. But as decades go by, the people who know the answers to exactly why we did things this way may not be around anymore. And so allowing lawsuits to go on in perpetuity requires a huge waste of everything. Yeah. It's sort of funny to me as we're talking about this, that the Supreme Court logic in some of these death penalty cases, like the Jones thing, right, where he had incompetent counsel twice at his trial and on appeal, and the Supreme Court said, well, too bad, so sad, we can't let you bring forward the evidence that would prove you're innocent, because it's important to have finality. It's important that this be settled, and that's more important. And then we come to the Supreme Court, decisions like this say, you know what? It's not important that rules be settled. It's important that private companies have a right to sue and to challenge settled rules. Yeah, you'd think that if you wanted to give that much deference to the idea of being able to challenge things, that you would include in that challenging cases, criminal cases, death row cases, where there's evidence of innocence. So, all right, let me pull up the legislative language and we'll look at this. So what we're doing essentially is just change the phrase that the Supreme Court got hung up on. Look at this language here. This is the statute that Congress passed. Every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. And the Supreme Court said, oh, well, the right of action can't accrue until the new, shell company was formed, the new business was formed. Then they have 6 years from that. And so clarifying what that means, 6 years after the last culpable act or omission of the defendant. So the last time after the government has done anything, after they've done something culpable, after they've changed something, after the government has acted, after 6 years have passed since the government has taken action on it, then every civil action commenced against the United States shall be barred. So this is how we can correct the corner post decision that essentially reversed Congress's policy on a statute of limitations. All right, we're making good time. I think we're going to get through all this before our hour is up. And so now we're going to get into automatic continuing appropriations. So sort of like the debt ceiling, this practice of shutting down the government is a pretty uniquely American thing. Other countries don't do this. Like, why would you? It doesn't make a lot of sense. Think about it, right? Congress hasn't fired anyone. Congress hasn't eliminated their jobs. So why would people have to stop performing those jobs? And, we don't stop paying taxes when the government doesn't pass a budget. It's all very nonsensical. And so, how many times there have been government shutdowns? 10 times. 10 times government has stopped performing functions that Congress has directed them to perform. Because somebody said, we're not going to pass a budget. You can't make us unless we get these concessions. And as we talked about in the findings, the costs of these shutdowns can be in the billions and billions of dollars that permanently get destroyed in our economy. This is silly. Nowhere else around the world do they do this. They all use common sense. We can too. We have the ability to apply common sense to Congress. So, Section 521, it makes automatic 14-day continuing appropriations. A continuing appropriation basically says, all right, this is how much we Congress authorized and spent previously, and 1/26 of that, 2 weeks worth, is what's being authorized now for the next 2 weeks. So every 2 weeks there would be a new continuing appropriation. It's what we're operating right now. We are in the fiscal year 2020, the 2025 fiscal year. Congress was supposed to pass a budget by the time the fiscal year started on October 1st, and they haven't done it. Congress didn't pass a budget. And again, this isn't a surprise. The budget is due October 1st every single year. And in my lifetime, you can count on one hand the number of times Congress has gotten its work done on time. Congress is failing to do its job. So let us help them. Let us make sure put an end to government shutdowns with an automatic 14-day continuing appropriations. I got to find the polling numbers on this, because once again, this is a pretty popular provision that people recognize. Shutting down the government is just silly. Where is it here? Appropriations. No, it's here somewhere. End government shutdowns with automatic continuing resolution. 67%. 67% support. Again, it's pretty common sense. So what happens then, right? If there's an automatic continuing resolution, if Congress does nothing, then why should they do anything, right? They passed the 2001 authorization for military force as a blank check, and then said, okay, well, we've authorized the president to just conduct the endless wars in the Middle East using this 2001 authorization. So couldn't they just set one budget and then say, we're not going to do anything else, just let it continue automatically forever? In theory, they could. They could do that. Would they do that? You gotta consider the possibility, right? So, Section 522 gives them an incentive. While these automatic continuing resolutions are in place, there is no official paid travel while continuing resolutions are in place, and no use of campaign funds for travel. Go directly to Washington, do not pass go, and sit there until you get your work done. Again, this isn't a surprise. Congress knows they have to pass the budget every year. It's right there in the Constitution. Like, the Constitution is very clear that it's their responsibility to do it. So go to Washington and get it done. And let's just go ahead and pull this up. All right. Come on, where'd you go? All right, so Section 521, the automatic continuing on or after the first day of each fiscal year. So we're going to talk about in a second. This will be effective at the end of the 2025 fiscal year, because we've already started the 2025 fiscal year. So it will go into effect the first time an automatic continuing appropriation would kick in would be October 1st, 2025, sorry. All right, so if there's no continuing appropriations in fact, then they are granted the same as if they were for the previous year. After the end of the 14 days, can be extended for an additional 14-day period. So automatic continuing resolutions. And make sure the rate is the same, unless it's for an entitlement and other mandatory payments whose budget authority was provided for in Appropriations Act under a law, then you got to follow that. All right. And what else is worth pointing out here? If Congress does make an appropriation for a specific program or something like that, then this section shall not apply. And then, all right, 522, timely enactment of Appropriations Act. Okay, so these mean this covered employee, officer, or employer means members of Congress. And during an automatic continuing appropriation, and it puts limits on official travel, as we said. The only exceptions are to return to DC if they were not in DC when the period began. Funds can be obligated and expended for a single return trip. Travel within the capital region can still be covered. And if there's a national security event, right? If you need to evacuate Washington, then that's fine. Restrictions on the use of campaign funds. So we're adding contributions can be used except as provided currently for ordinary and necessary expenses incurred with duties of the individual as a holder of federal office, except as provided in subsection D. So we're adding a new restriction on the use of campaign funds for official travel during automatic continuing resolutions. During a covered period, you can't spend your campaign money on travel. So you got to do it on your own dime, not the taxpayer dime or your campaign's dime. Then procedures in the House and Senate of Representatives while these continuing resolutions are going on. They're blocked from doing anything else except for making appropriations or a motion to determine a quorum, and then on or after the 30th calendar day. So this would be into your third continuing resolution. Then there's a further exemption for nominations to fill vacancies, to confirmation hearings, those kind of things. And it shall not be in order to move to recess or adjourn. Congress has to stay in session until they get their work done. And shall not be in order to waive any of the provisions of paragraph 1 for more than 7 days. And it would require a affirmative vote of 2/3 of the members of the House of Congress chosen and sworn. So these are the restrictions that you put on Congress to say you've got to stay in Washington and get your work done, and don't do other stuff, no distractions, stay focused on passing a budget. Again, this isn't a surprise. You've known forever that the budget is due on October 1st. What is D a reference to? D is motion to proceed to appropriations. So you can bring it to the floor. Motion to get right to the appropriations things. For joint resolution, they don't have to lie over for a day. They can be debatable, and after that has been passed, a motion to approve. So this is to prevent the filibuster, essentially. So after no more than 6 hours of debate, the Senate shall vote on the motion to proceed. We talked about earlier about how whether or not you could pass a law or rule dictating how the chambers of Congress do their business. And here's another example from this, showing that yes, you can dictate. I forget where this. I'm sorry, I don't have it in my notes what legislation this came from, but yeah. All right, section 523. We're coming to wrap this up. Classification of budgetary effects. The budgetary effects, these are just a couple bookkeeping clarification things. So they are three reference updates here. Again, taken from model legislation that was previously introduced in Congress. So, all right, that we made it through. Made it through our 7 policies, and I think that's probably a good place to stop for tonight. Tomorrow we're going to talk about immigration stuff. But just once again, Congress has the ability to act. Congress has the ability to address all of these problems. We just need to make a way to make it wise and prudent for Congress to collaborate with us. And we can do that by unionizing as swing voters, by issuing this one set of demands across all 470 congressional races. So, you're invited to join a Fast for Peace on October 15th, coming up in 4 days. The fast is simple: 24 hours without food, no recreational intoxicants, drink all the water that you want. And as my own personal commitment to a nonviolent reshaping of the way politics works in the United States, I've been fasting since September 21st, so I'm in my 21st day. Feeling good, I'm keeping my electrolytes up, and I'm actually up to 180 pounds today, so I'm up a pound from yesterday. I've done a better job of getting hydrated. So, all right, I think that's about it. I'll wrap it up for the evening, and please join me again tomorrow at 7 p.m. Eastern Standard Time. Thanks. Have a good evening.